an attorney matter that got set over late to this docket. Ms. Bliss, are you in for Mr. Zandy on this?
That is correct, Your Honor.
Okay. So this did, let me see if it made its way. I was just notified this got set over to this docket. Let me see if it made its way into my Odyssey. So my understanding is that this got put back on one of the judge's calendars, but I had originally heard the motion and it sounds like there might be some disagreement about the agreed order. Is that correct? And I do have the proposed order prepared by Ms. Green's office. So go ahead.
And did Your Honor have the opportunity to review Mr. Zandy's objections? Those were filed late last week.
Oh, they did not give those to me. Let me see. Let me go through Odyssey. Give me just a minute. I think because this just got added to my docket so late, I may not have everything. For B, he's stating the court ordered father's visits to be specified as Wednesday, 4:30 and end at 6. The additional verbiage related to public school and homeschool consideration should be removed. That is correct. Ms. Green, what's your position on that?
Your Honor, the reason that's included is because at the time of filing, the child was being homeschooled, and the issue was when school began, father wasn't dropping off the child. As I said, the child is expected to attend public school now, but we did not address any of the issues with father not turning the child over for his homeschooling, and that's when we filed the original motion. So since you had mentioned concerns about the need for her filing multiple motions, I think it needs to be addressed that that wasn't heard or discussed because the matter had been set over and that had not been addressed, but that was an original motion. So that's why we're asking that be included.
Correct. So my ruling is going to be it was not addressed. I do recall that the only discussion was related to their current schooling status. So it was not addressed. I don't think it would be appropriate, or it is not appropriate to put it in this agreed order since it wasn't brought up at that proceeding. If the parties want to re-raise that in a different motion, that is certainly well within your prerogative. But I am going to strike us on 4B, starting with the word as and ending with schooled. So the period will, the 4B will end with end Thursday at 6 p.m. period. And then for C, Mr. Zandy is stating the order. Is someone talking?
No, Your Honor.
Oh, okay. If you're on Zoom and we're not actively calling your case, just go ahead and mute. Okay. So for C, the order should specify both parties shall cooperate in good faith to accommodate this provision. Go ahead, Ms. Bliss.
And Your Honor, my client just simply wants this provision added given the conflict between the parties. I know Mr. Zandy had indicated at the last hearing that he had already agreed to provide the information to Ms. Wynn, but given the conflict between the parties, I think it needs some cooperation language needs to be included in there to prevent future motions from coming forth in the future.
Okay. Ms. Green, your position on that?
So again, the court didn't make a ruling on this. We added in the language that father's counsel agreed to provide the passport information. So as far as both parties cooperating, it's Mr's responsibility to provide that information. My client doesn't have any ability to have any control over that. So asking them to cooperate doesn't really work in this situation.
Yeah, I'm going to agree with Ms. Green on this, and I'm going to leave 4C as stated. Certainly, I'm going to say to the parties, I would hope that father and mother are cooperating in good faith to accommodate this provision, but it was not a specific ruling from the hearing. So I'll leave 4C as proposed by Ms. Green. 4E is the other, the next objection. Mr. Zandy states the court found insufficient evidence suggesting petitioner was not complying with domestic violence treatment. We did set it over to August 8th for any remaining issues related to that matter. Court did not require new release of the center. Further information is detailed in the proposed order. Ms. Green, your proposal is court resumes ruling on father's requirement to provide compliance reports and set a review for August 8th at 1 p.m. for further consideration. Okay. And so Ms. Bliss, I do think that Ms. Green's proposed 4E does adequately reflect what we talked about at the hearing, but go ahead and make any argument you would like to.
And Your Honor, I guess my understanding, and I did watch the hearing not knowing that I was going to be
Of course.
presenting today, so conveniently enough, I was present. So I do recall a little bit, but not a lot. It was my understanding that Your Honor just simply didn't make a ruling as to any future requirement or anything like that, but I don't believe Your Honor reserved on that ruling. So I think Mr. Zandy was requesting that instead of court reserves on ruling, it would be that court denies that ruling. Obviously, Ms. Green had acknowledged in that hearing that she had already received the compliance reports, or that her client had been able to receive those compliance reports directly from Ms. Lovely. So I don't believe that this provision being included accurately reflects what occurred in the hearing, and it simply implies that in the future, father may be required to provide more, but I don't think that that was addressed in the hearing or ordered by the court.
Let me go back to the notes. Does the clerk's notes do reflect that I reserved ruling on compliance and did set that to August 8th at 1 o'clock? So I do believe that, did you already have that compliance hearing?
No, I think that's what we're before the court on today. Ms. Green, you can correct me if I'm wrong.
So Mr. Zandy did advise Ms. Fassett that reports have been provided. We have received a completion report now, but the issue was the court order required father to provide mother compliance reports, which I acknowledge we'd received one at the time of hearing, that they were available monthly, and he has failed to provide anything. Mr. Zandy did file his recent compliance for completion of treatment and the one compliance report we had for July, but nothing else has been provided by father to date. So that's where we're at on that.
Yeah, it's a little difficult because it's mixing. So my prior, or for purposes of this order, I did reserve ruling on compliance. So that is a correct statement. What's happened is that instead of the compliance hearing happening yesterday, it got moved to today. So I think it's kind of two separate things. And I think when we made that original ruling, we looked at, because I do see the August 4th compliance report has been provided to the court. Ms. Green, are there objections to compliance at this point? And I guess I'm taking that as a standalone issue to this order, which reflects my prior ruling.
So the objection about his compliance is that he failed to provide any reports as ordered by the court order in the temporary parenting plan. So we are concerned that he was not compliant with the order, but he has, according to Ms. Lovely, completed treatment. So it's a problem because you were uncertain at the hearing what necessarily had to be provided because it wasn't clear in the order. It said compliance reports or proof of compliance needed to be provided. Nothing had been provided by father throughout the treatment. So that's where we're at. We don't believe that he was compliant, but treatment has been completed at this point. So I don't know if could be a finding that he failed to comply during the time he was completing treatment to provide any reports whatsoever. That's what we're asking for.
Yeah, I think what we talked about at the last hearing was this isn't a situation, as we know how some of these agencies work. It's not a situation where we can guarantee on August 1st or on July 1st or on June 1st, there's always going to be a compliance report. I am not going to find someone non-compliant who has provided proof of completion now of this type of program. So my proposal for the order that's in front of me, which is based on our July 11th hearing, I am going to leave it as stated in the in 4E. I do think that adequately reflects what we discussed. I don't think it's asking for any new releases. It just states has signed the relevant releases and is providing records as required in the court order at the review hearing. That was simply based on the court's prior ruling that he was to provide compliance with treatment. So I'm going to leave 4E as stated in the current proposed order, but I'm also making a finding today that he is compliant with those requirements per the court's order. Both parties' requests for attorney fees are denied. Ms. Bliss, go ahead.
And Your Honor, as Mr. Sandy put in his objections at the hearing, and I do actually recall this part, so my memory is serving me correctly-ish, at least as of right now, Your Honor did express some significant concern regarding the motion brought by Ms. Nguyen that it had just been ruled on by Judge Evans just a few months, I believe, prior. Your Honor did make some specific findings that there wasn't any factual basis or enough evidence to justify bringing this back before the court again. You did deny both our client's request for fees and Ms. Nguyen's request for fees, but Your Honor did explicitly say she would be subject to additional fees in the future if motions like this were brought back before the court. I think omitting that from the order is setting us up for the same position in front of, yet again, another judicial officer. So we would request the court add some specific language in there indicating if another motion is brought back before the court similar to this, that fees would be awarded.
Ms. Green.
And Your Honor, I would expect that information would be dicta and it wasn't part of the order. It was also not one-sided to Ms. Nguyen. I believe specifically you said it was unfortunate that this had to be brought, and it was concerning that it was brought, but I don't believe that the issue was that either one of them was at fault for filing the motion. You hadn't acknowledged that the passport paperwork wasn't provided. You acknowledged that there was substantial compliance, but he did not correct anything that was wrong. There were a number of issues that the calendaring of the time pickups and drop-offs had to be changed by agreement. So I don't think it was a one-sided issue where it's just Ms. Nguyen who would be at concern if another motion was filed, because some things had to be resolved.
And I do recall that specific discussion as well. 4F stating simply both parties' requests for attorney fees are denied is accurate. I think putting in perspective language, I mean, I think my oral ruling was more of a kind of a prospective, I guess, warning that the court likely would consider attorney fees if this became a habit of filing these types of motions well in a short period of time from a prior order. And I do think that was primarily directed at Ms. Nguyen, to be frank. But I am going to leave 4F as stated here. I think it's accurate. Certainly, the court has the minutes if additional motions are brought and it's back in front of Judge Fassett or back in front of me. We certainly would take into account the statements made at that hearing in assessing any future attorney fees. But I am going to leave 4F as stated in Ms. Green's proposal. Anything else from the parties? I think if one of you wants to present to me an order showing my ruling that father is compliant with the treatment, I'm happy to sign that.
And so I guess I just want to clarify, because you mentioned you had the proposed order. So are you entering the corrections today in the order that we've had today, or do we need to sign that?
Yeah, the only correction I made was on 4B. I struck out the end of the last sentence. And so I just have crossed through it and put my initials next to it.
Okay, thank you.
And I'm more than happy to provide an order, but would Your Honor, just to save our clients fees and costs, would Your Honor mind just entering a bench order to that effect, since it's just a simple one line? Or?
Any other day, I would say probably absolutely 1,000%, but they have me on docket straight through about 4 p.m. today. So I worry that it will get missed on my end. So if one of you could shoot that over, then it will just make sure it gets done. But I certainly understand the concern. Do we have Eddie? Is it Seraphin? Thank you so much. Thank you both.
Yeah, it's Seraphin.
Is Mr. Seraphin with us? Okay. So Ms. Carroll, I am not seeing Mr. Seraphin online. I don't know if you have any knowledge about his appearance today.
I don't. He wasn't happy with the change planned and filing, so I'm not sure if he even plans to come in and talk about it or not.
Yeah, my concern is, so the summons was served on him. He has technically 20 days to respond. He was served after 5 p.m. on July 20th, which, not counting the day of service, would give him until the end of today to file any type of objection. So I can't, if we had timely service, we could move forward even without his appearance. Because of the service concern I have, I can't move forward today without his appearance. he is given the opportunity to respond with any objection to the motion. So we will have to set this over. He will have to be notified of a new hearing date for it. So the best I can do is have you renote this for a week or two out so that he has that full 20 days to file a response.
I could try to call him and see why he's not making his appearance.
I can recall your case. If you want to try to make contact with him to log in, that is absolutely fine. And then we can come back to you.
Okay. All right. Let me try that.
If he's not objecting, or if he is objecting, we could set it on for the actual adequate cause hearing. I just don't have any response from him, but his time for filing hasn't ended yet.
We have court right now. Are you going to make it on Zoom?
I'm on Zoom right now. That's not connecting.
Okay. She just called you.
Did she? Yeah, I didn't get anything. I'll try Zoom again.
Well, take it off mute too.
What are the last four of the phone number?
What is it? What's the last four of your phone number?
7131.
7131.
I have someone ending in 2750 that keeps talking. I'm not sure who that is.
Connecting for a long time.
Oh, sorry about that. I'll mute it.
Okay. He could be in the wrong Zoom courtroom. There's no one with that phone number in our courtroom, and there's no one in the waiting room.
Can you hear the judge who said you might be in the wrong courtroom?
Oh, 2750 number?
7131.
Okay. Yeah, 2750. Who keeps speaking? What is her name?
Oh, Jacob Wyand.
Okay, please go ahead and mute.
Online. So
Okay.
you might be connected to the wrong Zoom courtroom.
Okay, so I'm gonna go ahead and mute, ma'am. When I see him pop in, we'll recall your case.
Okay, thank you.
Okay. Hart and Catherine Hart. I'm gonna take.
Yes.
Okay. Good morning, folks. Let me just jump into the digital file here. So by my notes, when we were here last, we set this review to see how visitation was going. We wanted the mental health evaluation to come in and then just see if there were other issues that were popping up for the parties as we were making some of these adjustments to visitation.
Yes.
Go ahead, Mr. Hart.
The visitation seems to be going well. Eric has had a little bit of attitude. We have him signed up for counseling. He had his intake last week or this week. He had his intake last week. The counseling sessions are supposed to be via Zoom, and so I'm just waiting for the counselor scheduler to call to make that appointment.
Okay. And then I did get the mental health evaluation that was filed. Ms. Call, did you receive that also?
I did, yes.
Okay, and it looks like we're fully compliant there. I don't have any concerns. Ms. Call, what's your position on compliance with that?
I have no concerns around compliance. I wanted to address a couple other things that were in my recommendations if we have a chance, Your Honor. But I mean, in terms of compliance, I think everybody's doing really, really well.
Okay, so Mr. Hart, I'll find that you are compliant with the mental health evaluation component that we were to review. And I'll turn it over, Ms. Call first. Ms. Hart, I will come to you for input as well. But Ms. Call, go ahead.
One of the concerns that I bring up in the report is regarding the fact that kiddo actually does in fact live with his grandparents across the street at this point in time. And grandma is being tested for, or is in the process of being tested for Alzheimer's. And there have been a number of reported falls and some issues with memory. And so I would like to address a plan for kiddo should grandma and grandpa be unable to take care of him the way that they have been to this point. One of the recommendations I put in the report was to receive information regarding that testing and kind of what's going on with her medical conditions, just to ensure that, because at this point in time, Eric actually doesn't have a bedroom or a place, at least during my period of time within the investigation, didn't have a bedroom or a place to sleep at Mr. Hart's house. And I know there was concern around safety for some of the other children with some of kiddo's stuff that he's got going on. So I just wanted to address that and kind of hear what a plan was for that and how we can address that issue.
And I do see that in your recommendation that there should be an ROI sign so we can get a copy of that assessment. Mr. Hart, first I'll hear from you on that. Do you have any objection to that? I think the court understands Ms. Call's position and certainly is inclined to require that. What's your position?
I mean, my position's whatever the court orders is what it is. My mom's falls, like most of the falling is just because of stuff being on the ground.
Mhm.
So I mean, like that's mainly it. It's just like a rug in the wrong spot. She tripped on a transition at one point, but
You know, and I don't want to get too deep into her medical conditions, except to just ask you, has she had that assessment yet, or is that still upcoming for
I think she did. I know that like she hasn't been to the doctor for that in a while, so I'm not positive.
Okay. And Ms.
But
Hart,
I know that she agreed. I know she agreed to sign it. So
okay. Ms. Hart, any input on that issue? I assume you probably are in favor of that.
Yeah, that's fine.
Okay. So yes, Mr. Hart, I am going to ask that because that is where where kiddo is living, that you work with your mom to get that ROI signed so Ms. Call can review that information so that we can make sure the best safety plan is in place.
yeah. Okay.
Go ahead, Ms. Call.
Well, I just was curious, Mr. Hart, if there was a plan for it. Will Eric be moving back with you? Is the plan at this point in time that he stay at Grandma and Grandpa's house, or has there been a conversation around that yet?
That's always been the plan. If there's any type of issue with him staying over there, he can come here. We have 2 spare rooms here that like I forgot to show you the basement, but we have a basement with plenty of room down there. And then we have a toy room that is my youngest son's toy room, but that it is very easily changed into a full bedroom at any point. It just needs a bed rather than a day bed in there. So
Okay.
like at any time when Eric needs to come here, when and if he does need to come here, like would just take a day to switch over a room to be completely like for him. We've already talked about that. So
Okay, thank you. I also want to acknowledge, Your Honor, that Ms. Hart shared with me that Mr. Hart and Ms. Hart, pardon me, have been doing a really great job of communicating with one another and getting along very well and scheduling visits. They're communicating really well over our family wizard. Ms. Hart's uploading all the documents she needs to be doing. Assessments are getting done. I think this is a really positive move forward for everybody involved.
Good. I think that this is good. I'm just kind of looking back at the history. So well done to both of you. I know that's probably not how this most recent iteration of reviewing a parenting plan started communication wise. So, kudos to both of you. Your kiddo's going to benefit from that for sure. What I'm looking at, I do want to do a review date for the medical records review by Ms. Call for Ms. Hart, grandmother Hart. What I also want to do is put a plan into place for what it looks like to me is before my involvement, kind of why we're here is there was originally a motion for adequate cause to change a parenting plan. And then Ms. Call was appointed and the court essentially reserved on adequate cause. So I do think at the next review date, I want to put a plan into place for how do we get to finalizing a parenting plan that works for everyone so we can actually keep this moving forward and you're not just coming back for piecemeal reviews along the way.
all righty.
Okay. Ms. Cole, how much time do you think? So my plan is step 1, let's set a review date to get an updated medical with grandma. And then we'll set a schedule in place for looking at the parenting plan kind of in total.
Well, I mean, I think it depends on if that assessment's been done or not. If the assessment's been done, I can have that wrapped up fairly quickly and we can come back by the end of the month.
Okay.
If we're still waiting for the assessment to be done, I don't know, to be honest. It would depend on the timing of that. But my impression of what's happening at this point in time is that I think these are parents who could move towards a final parenting plan agreement. It may take some negotiating and some talking, I know Ms. Hart's very anxious, and I understand why, to have in-person visitation with kiddo, and she's actually got a family member, a trusted family member moving to kind of help be a part of all of that in terms of supervisors. I know that was part of the conversation last time we met as well, was that we were struggling to find lay supervisors who would fit, and I know Mr. Hart has come to an agreement about who those people could be. So that's really good news. I would like to ensure, as we move towards that final parenting plan, that we really are honoring a schedule that is most beneficial to Eric in terms of transitions, especially with his latest diagnosis and his mental health assessment, that we really honor a slow process that prevents him from having too much change too quickly. And so while I know there's a lot of anxiousness around wanting those visits and wanting to be close and have overnights and all of those, I would really like to see the parents come to an agreement about what that step-by-step process looks like in terms of making sure Eric is safe through all of that. So for that purpose, I mean, I think if we're able to address what's going on with Grandma Hart by the end of the month, I would imagine that by the end of September, we could come to a final parenting plan agreement, if not sooner.
Okay. So why don't we set August 30th if everyone's in town? I know we're kind of dealing with last minute summer vacation schedules. So if that doesn't work, I'm happy to move it.
Well, to be honest with you, Your Honor, it's the first day of school that day, so that may be a difficult day.
Do we want to look at September 6th then?
That works for me, Your Honor.
Ms. Hart, does that work for you?
Yes, that should be fine.
And Mr. Hart?
Yeah, that should be fine.
Okay, so let's set this for September 6th. This will be a review and particularly related to, and an update on grandmother's ability, I guess, to continue having the child reside with her. And then what we'll do on September 6th, what I would like to do is maybe come up with a schedule for encouraging, and we can do it through formal mediation, or if you all think that you could work together and don't feel like you need to go through the mediation process to come up with an agreed parenting plan. And when I say agreed, I mean, my thought is, it sounds as if there might be key points you agree on, and then maybe little things you want the court to decide, and that's fine. I certainly know that maybe you're not 100% in sync with every little request, but like you heard from Ms. Call, it sounds like you two are kind of working together pretty well right now in the child's best interest. So maybe we can set a schedule for bringing you all back to talk about this parenting plan.
Yep. During last court date, we were talking about starting the supervised visits. Mm-hmm. And between Mr. Hart and Ms. Call, I think we were all in agreement that the supervised visits would be starting here fairly quickly. And I believe that Mr. Hart and I had agreed that once Eric has his initial counseling session, that we should start the supervised visits. My mom has flown into town. She flew in yesterday so that she could be there for those visits. And I spoke with Ms. Call and Mr. Hart about maybe being able to do twice a week while mom's here, to start those visits, because, well, my mom's here to help with that.
And how long is your mom in town?
Until the 24th of this month.
Until August 24th?
Yes.
And when did counseling start? I did not write that date down for kiddo.
It hasn't actually started yet. We just got his intake, and I'm waiting for the scheduler to give me a call. But I can call him today and find out what's up with that. Okay.
And this is the grandparent that kiddo visited recently, yeah. Correct?
Yeah,
that's correct.
Okay. Ms. Call, what's your input on twice a week supervised visitation while this grandmother's in town?
I'm in support of that, but I very much agree with Mr. Hart that kiddo should be in counseling actively before that begins. And I understand we've got a time frame with grandma, but I also know Mr. Hart put forth some names of people who he trusted to be a part of that visitation plan as well. And I think that's a fair request, that we make sure that Eric has adequate counseling happening, and that we have people that both parents feel comfortable with that are able to supervise those visits. I also think starting out with a shorter visit to begin with would be really important, because we've had these 30-minute digital visits that have gone very, very well. But I know Mr. Hart has also recognized that there's been some behavioral shifts, and we know that for this particular kiddo, shifts in environment, quick changes that happen to the schedule, or even new factors of things he doesn't quite know how to communicate emotion around or how to express concerns around. He's still learning how to even identify that he's having those feelings. And now he's actually been diagnosed with something that helps us understand that even more. And so I think I support Mr. Hart very well in saying that, can we at least make sure that we have active counseling in place and someone who can help kiddo address those feelings and that experience. And then also to make sure we do, since we do have other supervisors who Mr. Hart feels comfortable with, I think if timing works out, I think it's wonderful that grandma can be there. That's the trusted person that all three of these people know and Eric trusts implicitly and loves very much and has a great bonded relationship with. And I know he'll feel safe in her presence. But I also think it's important that we make sure all that scaffolding is still in place for him as well.
Okay. I do. Okay. And Ms. Hart, I see you shaking your head. I think that makes a lot of sense. And it sounds like, the three of you are in agreement. Again, kudos to you all for kind of understanding. I know Ms. Hart, your inclination is probably, or your desire is, let's do it now. I want to see my kid. But, it does show the court a lot that you're willing to wait on that to get counseling started so that that structure is in place. So what I'll do right now, because I do, I hate to say it, but if there isn't an appointment already set up, knowing wait times for getting counseling appointments for folks, I don't know if it's realistic to think that kiddo would be started before the 24th to actually say, hey, let's do visitation. So I think my oral ruling today will be, we'll start supervised visitation once counseling has started. And then Mr. Hart, if you just keep Ms. Call and Ms. Hart informed when that counseling session is, that would be helpful.
All righty.
Okay. And then certainly we can readdress that when we're back together. Okay.
All right.
Anything else for the parties today?
So let's say like when I call today, and they say like he can start tomorrow, can Eric go see her like the day after the counseling session starts? Or do we need to come back to court? Or how does that work?
Ms. Call, do you have a preference on timing with the starting of counseling versus, I think the concern, Mr. Hart, is just that there would be someone that kiddo's established with that should he want to talk about an up or down of how that visitation went, he would have that in place already. So I'm going to reverse. I was going to say I'm just going to do an oral ruling, but I will go ahead and do a bench order that states between now and our next review date, if counseling has started, then a supervised visitation, let's say up to 2 times a week. And I'm not specifically going to say grandmother, but I'll say agreed supervisor, 2 times a week. Ms. Call, timing on those visits, 1 hour to start with?
I think starting with an hour is wise. Yeah. And I also think, just in terms of this question, I think I would be in favor of even if the appointment's tomorrow, Eric starting very soon after that. Because the other thing about having that counselor in place is that can actually be a resource for Mr. Hart and Ms. Hart as well. They're going to get insight into Eric's responses. They're going to be able to communicate with the counselor as well. So I think it's just about having that position in place more than it is about the court timing for me.
Okay, great. So that's really helpful. So yeah, I think what we'll just do, so you guys have some guidance, but certainly feel free to work together on what feels, right to Mr. Hart and Ms. Hart and the counselor and kiddo. But our kind of framework will be up to twice a week, up to an hour each time with an agreed supervisor. And then we'll revisit that on September 6th. Okay.
Okay.
The other thing, I don't know if I need to mention it here, like we're going camping the 16th, 17th, and 18th. Okay. I'm just letting the court know, like we'll be out of town, but I don't think that it's going to affect anything because he can just make the calls around those dates. So, there you go. Sorry about that.
Ms. Hart, any issue that you need the court to be involved with sounds like a 3-day camping trip?
No, we can just arrange calls and visits around that. That's fine.
Okay. Well, again, see, you guys are making real progress from the first time that we were all on docket together. So kudos to you. Okay. I'll get that bench order signed and then we are here on Ms. Carroll's motion for adequate cause to change a parenting plan. Mr. Serafine, have you had a chance? It does look like you were served with those papers. Have you received those?
Yeah, I received it.
Okay. Do you plan on filing an objection?
Yes.
Okay. When are you going to get that filed?
This week. I'm still working on it.
Okay. So technically, what I have time-wise, would be end of business day today for your objection period.
Okay.
Do you think you can get it done in that time frame?
For what day is it?
What do you mean? What day is it?
Like you said, the time frame.
So your 20 days to respond ends today at 5 p.m. End of business today.
Yeah.
Oh, not 5 o'clock. What time?
So we pulled the machine at 4:15, so you need to be here before
4:15. Okay. So for the clerk's office for timely filing, you'd need to be here before 4:15.
Okay.
Can you get that done today?
Yes.
Okay. So then if you are going to be filing an objection, and I will note orally that you've stated today that you're objecting, what we need to do is set you to a new Wednesday at 9 a.m. for an adequate cause hearing. And that's when the two of you would be making oral argument about why you do believe there's adequate cause to change the parenting plan or why you believe there is not. We can pick any Wednesday at 9 a.m. It could be as soon as next Wednesday. No, can we do next Wednesday, the 16th? Our docket is open. Do you guys want to do it next Wednesday at 9 a.m.?
Can we push it another week?
To the 23rd?
Yeah.
Are you available on the 23rd, ma'am?
Yeah.
Okay, so let's do August 23rd for our adequate cause hearing at 9 a.m. And if either party plans to submit declarations or affidavits in support of their position, feel free to do that up to 5 days before that hearing date. Okay. All right, and then Mr. Serafine, make sure to get that objection filed if you're going to be objecting.
Thank you, Your Honor.
Okay, thank you both. Any questions for the court right now?
I do have it. If he doesn't get that objection filed today before 4:15, will that court date still exist?
It will. I mean, his oral objection, his appearance and his oral objection, the court would likely find that it's been timely made. My preference is that we would have documentation. Certainly, ma'am, you could make an argument that it's not timely filed if he doesn't get it in today. And then we would address that before we go on to the adequate cause hearing. 08. Okay. And then Aaron Gilbert, I see you there online. Right,
yes.
Okay, let me just get into your digital file here. So what we did at our last hearing was set over the show cause hearing because it sounded like to me that Ms. Gilbert wanted some additional time to respond. And yes. I have received on August 7th some additional filing from you, Ms. Gilbert.
Yes, which I just realized I didn't give to Keith, but yes.
That you didn't, give that information to the guardian ad litem?
Yeah.
Okay. So hold on, I'm just working with it. So let me just start with Mr. Lawrence. It sounds like there was additional filing from Ms. Gilbert that you may not have in support of the motion to change a parenting plan.
I have not seen those, Your Honor.
Okay.
Sorry.
And it looks like it's, probably relevant information for the guardian ad litem by way of police reports, which my gut instinct tells me are probably a big basis for you bringing this motion. Is that correct to say?
Correct.
Okay. So what I'd like to do, unless Mr. Lawrence wants to move forward anyway, but my preference would be for just to set this out 1 week and have you get that information to Mr. Lawrence so that the court is able to have his input before making a decision on this.
Can I object to that, Your Honor? I can't miss work every week to continue on. I'm going to lose my job. I'm currently paid up on all my child support, everything else. I did everything the court's asked. The drug test, all the samples, everything came back negative.
Go ahead, ma'am.
I mean,
I heard you, Mr. Gilbert. I heard you, Mr. Gilbert. I'll hear from the other parties and then I'll make a decision.
I mean, I did let Keith know that I had found out that that Brenda was arrested and had her daughter, kind of taken out of the home. She just has supervised visitation too. So, and then I guess, so my next step is, wanting to get the information from Lewis County, so I can see what's going on with her case. So yeah, I don't know if you want to just do another week or if we want to wait until I actually have that information, from Lewis County.
So here's what I would say, ma'am. If this is your motion for adequate cause to change a parenting plan, but you have additional information that you plan to file in support of it, the court's inclination would be simply that we would strike today's hearing. You renote this when you're ready for the court to decide a motion on adequate cause.
Oh, okay. So after I have the information, then I would just file it and set a new
Right.
court date.
I would say bring this motion back before the court once you believe the filing is complete and you're ready to go to hearing. It sounds like the last time we met and then today there's additional information you want the court to consider.
Right. Unfortunately, yeah. Last time I didn't realize it was going to open a can of worms. So
yeah, right. I get it. Mr. Lawrence, I guess I'll turn to you. It sounds to me like that Ms. Gilbert, the moving party, isn't necessarily prepared to move forward on her adequate cause motion today.
That's fine, Your Honor. I did review the records in Odyssey to see what I could find on Brenda Gilbert. I didn't find anything that I thought may have been an issue. And so whatever arrest she may have had isn't resolved yet. And so I think that having Ms. Wilbanks renote it once she has the information she wants us to look at would be the best course of action.
In the meantime, I did want to say, John does supervised visitation and Max, our son, is in sports and has asked if his dad can come to his games. So I don't know if that's a possibility in the meantime, if it's, obviously I'm going to be there. So is it okay that John comes to his stuff down here? Or?
If you, ma'am, as the moving party and the one with the concerns in this case, are open to allowing him to be in person at the games, the court has no issue with that whatsoever.
Okay, thank you.
Mr. Gilbert, what I think that we'll do then is I'm not setting a new date. Ms. Do you still go by Gilbert, ma'am?
Yeah.
Okay. I just want to make sure I was using the right name. I know sometimes these cases start with the married name and then change. So Ms. Gilbert, what I would ask, because there is a bench order in place that does put some restrictions on visitation, I would ask, I'm not going to set a date, but please get this back in front of the court in a timely manner so that we can fully address for Mr. Gilbert what that looks like going forward. Okay.
Yes, definitely. Thank you.
But Mr. Gilbert, the court has no issue with you attending sporting events per Ms. Gilbert's request.
Okay, I'm asking the court. I was ordered to do the hair follicle test, this, that, everything else and stuff. It all comes back. I said I don't do drugs. Everything's came back negative. I got no evaluations. What does the court want me to do so I get my week on, week off before summer's over? She will never be happy. She's not going to let me give visitation. I need to address the court. What am I failing at?
Mm-hmm.
I paid all my child support. Every drug test came back.
So Ms. Gilbert, let me ask you this. The reason the court puts changed visitation was because you filed a motion for adequate cause wanting to change the parenting plan. Are you still asking for supervised visitation versus going back to the original parenting plan?
Yes. This whole thing.
Hold on, Mr. Gilbert.
This whole thing was not just about drugs. It was the complete chaos that is happening at their house, and it has seemed to continue. And so that's my concern. And just this morning, Mr. Gilbert texted me and said, I'm probably right that Max probably shouldn't be there right now while he's going through this. So yeah, I just, until I know that him and Brenda are done officially, I just feel like it's not a good environment for Max.
Okay, well then ma'am, I am going to change my ruling somewhat because here's what's happening. You have filed a motion to change a parenting plan. The court has put some additional restrictions in place without actually making a determination on that. But you're now saying you want to present more information and you're not ready to move forward on it. But I think Mr. Gilbert has an excellent point, which is in the meantime, while you're wanting to document the file with more information that we don't have, he's losing out on time with his child.
I do have the information that you know, his wife was just recently arrested because they got in a huge fight and he called the cops on her. That was just a month ago. So
Right.
nothing has calmed down.
Okay, then what I want you to do, here's going to be my ruling. Mr. Gilbert, it is going to require you all to come back to court next Wednesday. I'm going to, rather than keeping this out, I think you make an excellent point, sir, that the court has put additional restrictions on you for a lengthy amount of time without this matter moving forward. I do think we need to have resolution to that issue. So I think that I know, I understand what you're saying about missing work, but I do think you all should come back next Wednesday at 9 a.m. Ma'am, please get that information that you filed with the court to Mr. Lawrence. And I do want to make a ruling on your request to formally change the parenting plan, okay?
Okay.
So we'll be able to make a ruling next week and find out something?
So what it'll initially be is a ruling on whether there's adequate cause to change the parenting plan. If I find adequate cause, I can put a temporary plan into place and then set you all for trial on the permanent parenting plan. Or the court can find there isn't adequate cause to change the parenting plan.
Okay, I guess summer's gonna be over. All right, thanks.
Yeah.
He is the one that took 6 months to get a clean drug test.
Ma'am, there's no question in front of you. Please
Yes.
get that information to Mr. Lawrence. Mr. Lawrence, are you available next Wednesday on the 16th?
Yes, Your Honor.
Okay, I appreciate it. We'll see all the parties back on that date. Looks like you all
date.
back on July 14th were in front of Judge Scudder. You guys discussed visitation at that time. I believe Mr. Lawrence was assigned early July, so it's only been about a month. My notes just show that we are here for a review hearing with you, Mr. Lawrence, but the parties, since I'm newer to this case, please let me know if there's something else the parties are expecting to address today.
Your Honor, all I can indicate is that I've made contact with Mr. Becerra. I have talked to him about setting up an appointment next week to visit with him. I will be doing that toward either tomorrow or Friday. And I finally reached Ashley Becerra yesterday. I found out that she is now living in Astoria. And so again, she has to create a new email address for me, and I will be scheduling her for an appointment next week as well. So I'm just getting started on this.
Perfect. So it sounds like, and Mr., you know what, I forgot to even look. Do we have Ms. Becerra online? I don't see her. Was she present on July 14 in front of Judge Scudder? She was, and that's when he set this new date. So I just will note in our clerk's notes that she is not present today. My plan is just to set a new review date so that Mr. Lawrence can do those interviews. How much time are we thinking? Probably another 30 days?
Yes, Your Honor.
Mr. Becerra, does that work for you?
I'll make it work.
Okay. Well, thank you for being here today and for being proactive with getting your information to the GAL. If it works for the parties, let's set this to September 6th at 9 a.m.
Okay.
And that'll be for GAL compliance review. And hopefully we will have Ms. Becerra with us at that time.
Your Honor, my understanding is that she had to work
Thank
today,
you.
but we did communicate yesterday.
She was on for a while.
Yeah, hold on a second. Okay. Who? Okay.
I'm on here.
Okay, is this you on the wing tech, ma'am?
Yeah.
Okay. And then we have Ms. Looney on behalf of the state.
Good morning, Your Honor.
Good morning. What I show us here for is pretrial management. This was originally set previously, and I believe Ms. Entler, you were not available or wasn't present. It looks like you all had a readiness hearing yesterday in front of Judge Hahn, and you did agree to strike the trial date.
That is correct. We had agreed on a parenting plan, and I was going to see if we could send it over for at least a week because we just recently agreed on it, and I need to take it down to the courthouse and submit it.
Okay. And then Ms. Looney, is that something they would file with you as well?
Yes, I will need a copy of that, Your Honor. Custody has been back and forth for the children, so we need to know what they've agreed on so we can accurately calculate the child support.
So yes, we'll set a new date here in a minute. Congratulations on, being close to a joint agreement. I think that's great for all parties. We'll set that date, but just make sure when you guys do file that with the court clerk, that you're also filing that with the prosecutor's office so they can review it for their involvement. Okay.
Okay. And are they there at the courthouse, or where are they at? So I know where to take that to.
We are not at the courthouse. You should have received paperwork from us recently with our address. We are at 1338 on Commerce Avenue.
I have not received anything from you guys.
Okay. If you haven't, you should be soon. With the proposed order, it was sent out on July 21st.
Okay.
And she did give you that address, 1338 Commerce.
Okay.
And Suite 305.
Thank you.
You can just drop the paperwork through the slot by the door.
Okay.
Okay. So how much time are you all wanting to get this back in front of the court?
Can you push it out 2 weeks, no later than 2 weeks?
Yeah, that would be August 23rd. Mr. Entler, does that work for you?
Yeah, that's fine.
And Ms. Turnbull?
I'm double checking.
Okay. And Ms.
Yes, that works fine.
Okay. And Ms. Looney, August 23rd at 9 a.m. work for you?
That will work for the state. If we can also just note to add to address child support at the same time.
Perfect. So we'll put that in our minutes that we will be addressing hopefully an agreed parenting plan. Certainly if there's some small issues you need the court to rule on, that is fine. Our hope is just that you're 90% to 95% of the way there. Okay. And then the child support, we will also address at that time based on the state's request.
Thank you, Your Honor.
Thank you.
Ms. Turnbull, anything else on that matter? We have
not on that matter. No.
Luis Kozar present.
Yes, Your Honor.
Okay. Let me just get into your digital file here. So when we were last together, we did just recently appoint Ms. Turnbull on this matter. I guess, Ms. Turnbull, I'll turn it over to you. I know we haven't given you a whole ton of time on this case. So you can just let me know where you're at and we can decide where to go from there.
Sure. My understanding is this is mainly a compliance hearing, and both parties have returned their paperwork and been in touch with me. We're in the process of setting up interviews and moving forward. So I would say both parties are in compliance and we're moving forward.
Okay. And Ms. Lawrence, from your perspective, is that correct?
Yeah.
And Mr. Kozar?
Yes, Your Honor.
Okay. And then Ms. Looney, it looks like I do also have you on this one for proposed child support.
Yes, Your Honor, but we're not addressing child support today, so the state has nothing to add.
Great, thank you so much. So it sounds like we just need to set this out for another review date. Is that correct, Ms. Turnbull?
Yes, I do believe that there is a GAL review scheduled.
Oh, did we already get it on there? Okay.
And I don't have that date in front of me, but I can look.
There, September, we do. You are correct. Thank you to the court. September 6th at 9 a.m. We've already got you on there. Does that work for the parties?
Yeah, that works for me.
It works for me as well.
Yeah, that should be fine.
Okay. All right. We'll see you folks back on September 6th. Keep working with Ms. Turnbull. And on this one, sir, I received from you a motion to transfer this case to mandatory mediation.
Yes.
And you did supply a form for that with a lot of additional information that would not be typical, essentially you supplied the court an order in the form of a motion with argument in it. So it's not something the court could accept as an actual proposed order. It does look like the petition, response to petition for a parenting plan, child support, etc., was served on you, sir, by Ms. Gibson on July 20th. But what I don't see, and you can help me out, sir, is whether your motion, what appears to be your motion, even though it's called an order, transferring the case to mandatory mediation was served on her.
It was. I got the sheriff's office to serve her with that.
Okay, and when was it served?
It was served last week. I don't have the exact date. They sent me the proof of service, but it said it was filed. The proof of service was filed.
What date?
It would have been either the 2nd or 3rd of August. It hasn't came in the mail to me yet, so.
I don't have a proof of service of your motion. I only have proof of service of the documents on you on August 2nd. I don't have proof of service of your motion on her. And since she is not here, kind of confirms my belief that there has not been timely service to proceed on this motion today.
So the sheriff's office didn't serve her then?
I have no proof. I'm not going to say whether they did or didn't. What I can say standing here right now is there's nothing in my file to prove that she was served with your motion. Okay, so all I can do right now is strike today's hearing and have you renote it and serve her.
So if she has already been served, then I need to serve her again?
Sir, I'm going to repeat myself because I can't give legal advice from the bench. What I can tell you is my judicial file shows no proof of service on her. So I can't proceed today.
Perfect.
Okay, so I'm going to strike today's hearing. You are very welcome to renote this and file proof of service with the court. Okay? Do you have any questions for the court?
Why would the courthouse in Cowlitz County say that there is a proof of service filed when there isn't one?
So the proof of service that the court has states that it was service on you of the response to petition for a parenting plan and residential schedule and or child support. So if you called and asked if there was proof of service, and I'm just speculating here, I'm guessing someone saw that proof of service in the file. I'm telling you, I'm looking at my judicial file and I don't show proof of service of your motion.
Okay.
Okay. So I'll just go ahead and strike it. That doesn't cause any issues with you renoting this, and you're certainly free to bring this motion back in front of the court when she is served and proof is filed with the court. Okay.
Okay.
All right. Thanks for your time. You're free to log out. And Kirby Llewellyn.
That's correct, Your Honor.
And yes. I apologize. Is it Kirby Young now?
Yes, correct.
Okay. All right. Let me open up that file. Give me just a minute. So when we were together last, I think the big, Mr. Lawrence gave a great history of the case. And what we did today was essentially talked about the fact that there really is no parenting plan in place for you all, that we wanted to get some sort of answers for everyone. I do have in the file, this one is a proposed parenting plan filed by Mr. Utter back in February.
Your Honor.
Just a second. From February of 2023. That's the hard copy that's been handed to me. And I think we maybe talked about, hey, is that still what you all want to operate under. What I have received since our last hearing from Ms. Young is also a proposed parenting plan. Mr. Utter, have you had a chance to review the proposed parenting plan from Ms. Young?
Well, actually, Your Honor, we together signed a proposed parenting plan, went into the clerk's office together and filed one together with him.
This is, I'm looking at the very last page of what Ms. Young filed, and it has your signature on it for August 2, 2023.
I believe so. I don't have that paper in front of me, but the last paper was a tentative plan to get to the final one eventually. It was a typed one that I had typed out. And it says something to the regards of starting August 9th, which is today. Parker will be coming on Wednesdays from 4 to 8.
Yeah, so it's that's you didn't put it in order, but it is a standalone, just a blank white document that says to start parenting plan, first month starting August 9th, second month starting September 1st, third month starting October 1st. We'll go straight into permanent parenting plan as outlined.
Yes. And that's one that Kirby and I both have agreed on, sat down on, passed papers back and forth with. We've really worked together in order to do this. And if something wasn't right, one of us didn't like it, we talked about it, we compromised, we figured it out on our own. And here we are, we submitted it together to show the courts that we have something now, and we're really here for Parker, and we just want the best for him. And
okay, hold on. So Mr. Lawrence, have you reviewed the proposed parenting plan?
No, Your Honor. I spoke to Mr. Utter yesterday afternoon, and he didn't mention that they had filed something. So I didn't go and look because I wasn't served and didn't have notice. However, this case has started from a position where Mr. Utter and Ms. Young had difficulty in working together. Parker had just recently learned that Mr. Utter was his biological father, and I think they've done quite a good job in trying to get Parker comfortable being around Mr. Utter. There's been some alone time between Parker and Mr. Utter, and I would have no objections if they can both agree to this parenting plan. Because this is ultimately what we want, is both parents agreeing on how they should handle their own child. And so I would not stand in the way just because I haven't observed it at this point, but I am familiar with the parties and what they're trying to do.
Okay. So I think, and Ms. Young, does this meet with your understanding?
Yes.
And again, you may have heard me say this to some other folks, I really applaud you all for working together towards the best interest of your child. And reducing the amount of conflict between the two of you. That is great. Let me just check with the clerk. Do you have an original of that, the August 3rd filing? I don't think I do.
Unfortunately, we only had one copy, so we don't even have a copy, Your Honor.
So let's do this. Because the sheet that you filled out is, and let me preface this by saying, I understand going through these cases without a lawyer is difficult at best. But it sounds to me like what you all want to do is put a temporary parenting plan into place through October 1st. And you all have some visitation schedules through October 1st. And then after October 1st, you want the permanent parenting plan to go into effect. Is that correct?
Correct.
Yes.
Okay. So what I need from you is an actual, so the one page that you filed, that's not a temporary parenting plan. I mean, it tells me what you all want to do, but I need two things from you. I need one, you have filed the permanent parenting plan that you want in effect in October, but what I need you to present to the court for signature is the proposed temporary parenting plan in the actual form. And then what we'll do, and if you think you could get that filled out, since you've agreed to all the terms, if you could get that filled out within a week, we could set that on for what we call presentation next Wednesday, where I would just look over the form, make sure you've checked all the boxes you need to check. If you're still in agreement, We'll sign off on it, and then we'll set a review date in October to make sure that you all still are ready to move forward with the permanent parenting plan.
Okay.
Okay. Sir, does that work for you?
Well, when we were at the clerk's office, they had mentioned something that we may be able to not, if we could bypass the courts, if we agree on this and we get a facilitator.
You
Are
can
we on that now, or?
So you can make an appointment with the courthouse facilitator who will go through the parenting plan paperwork with you. And let me just be reminded by the court, when can they make those appointments?
They're generally on Fridays.
Okay.
Depending on what's open, how far out that's going to be. And
Okay.
they need to have all of their final documents prepared before they can make that appointment.
Yeah. So, and those are just for the final documents, right?
Right.
Yeah.
Child support.
Yeah.
Yeah, and that's what they had said. We had 3 more papers, a final, a child support document, and one other that the facilitator.
So here's what I'm going to recommend, because that won't apply to the temporary parenting plan you all want in place. So let's kind of baby step it. For next week for presentation, get me a filled out temporary parenting plan. And that's going to include the August, September schedule that you all want into place. Okay. And then we'll set a review date in October. And before October, you all can meet with a court facilitator to have them look through all of your final paperwork, including the final parenting plan, final family law order, final child support, etc.
Okay.
So for next week, and if you want to get Mr. Lawrence a copy of what you're proposing, I do think that would be helpful. You know, you want to say, obviously, if this is an agreement, probably neither Mr. Lawrence nor the court are going to stand in the way of that, absent some glaring safety issue to kiddo. But please get him a copy of that, just in case we need his input.
Okay.
So we'll set this to August 16th. That'll specifically be for presentation of the temporary order. And then at that date, we'll give you an October date to come back for the final orders.
Okay, so a question. So after the October one, we should be done. I mean, like we don't.
Sounds as if, based on what you all are telling me, yes, that sounds very correct.
Okay.
Okay.
Okay. And just for the courts, Your Honor, I mean, we're working together. I'm working with my work to get him on my insurance right now, waiting for a call back, and counseling. We're working on getting Parker in counseling, talk together about this, and just for the courts to be aware of.
No, great. I think you all are doing an excellent job. So keep up the good work. I have Ms. Bondurant. I have Mr. Bondurant. Mr. Bondurant, have you received, you have filed a response to the commissioner's request.
I was out of town and my 11-year-old was served, and I got it. I responded yesterday, but.
Yeah, typically it's supposed to be left with someone over the age of 18. So
yeah, it was left with my 11-year-old.
Let's not talk over each other. I'm hearing from Mr. Bondurant first. You're saying it was left with your 11-year-old?
Yes.
Okay. So my notes for personal service show that the process server left it with Melissa Betts, who they stated is a person of suitable age.
They had handed it to my 11-year-old, and then she went and got Mimi, which is their grandmother, and then she had came out. But originally it was handed to. Well,
okay. So it's an important detail, sir. So the process server did confirm there was someone of a suitable age that was there to receive the documents. The date of that service was Monday, August 7th. Is that correct? August 3rd. Sorry. They filed the service on the 7th. So it was filed on the 3rd. It sounds, sir, is there additional documentation that you're wanting to supply before here's this motion?
Yes, I have a few notes I would just like to throw out there. I have.
Hold on. I'm not asking for the argument. I'm asking because you were served so close in time to the hearing. Are you asking for any additional time to file documents with the court?
Yes, Your Honor.
Okay. What do you expect those documents to look like?
I have the actual custodial, like we have 50-50. She has the old documents. She missed court dates in December 2021, and I was given 50-50 custody with no child support. And for whatever reason, the documents they have at Cowlitz County are not correct. I have the correct documents, and me and her have been doing 50-50 for a year and a half. So yeah, I have all kinds of things. I have text messages. I've been kept from one of my children for now over a month. Okay, this is a whole mess, Your Honor.
Yeah.
And listen, I got away from this. This is not the first time I've been kept from my children. I've done everything right as a parent. I have never came out her as a mother. She's a good mother, but what's going on right now is purely out of spite. And I have not got to see my child over that. And she hasn't got to see her 5-year-old because of that, because I'm too afraid to give up my daughter because she won't let me have them back.
Yep.
She's known for.
So hold on. I'm just going through this. So I'm going to turn to Ms. Flick. You did originally file the motion for contempt hearing. Originally, because of timeframes, we would originally put that a month out to August 23rd. You did file a motion to shorten time. And the reason stated was essentially that you wanted to see the judge sooner, that you have some concerns about your daughter being returned to you, it sounds like.
Yes, she has been gone for 20 days from me and her sister. She was supposed to return after the weekend because we went back to our court-ordered every other weekend plan because of safety concerns, which I have a lawyer meeting next week about, so we could go back to custody court. But she has missed appointments. She's been gone for 17 and a half days from me and her sister, and they've never been apart. He has gone on road trips and left her with other people. And so he's not even spending time with her. And that's why we're going back to custody court for other safety concerns.
So let me ask, where's the child now?
I have her, Your Honor.
He has our oldest, and my mom took our youngest to her speech therapy appointment.
Okay. So, Mr. Bondurant, I understand that you want to file additional information with this court. I guess my concern in the interim is the only parenting plan I have in place is a 2021 parenting plan that states that children under school age are supposed to live with Taylor, except with you, sir, on weekends every other week. And then you also get them during week on days off.
Yeah, there was an updated one. She missed court. It was during COVID. I have the documents, and furthermore, Your Honor, we were co-parenting for a year and a half.
Stop. I don't have that in my file. So what's the date of that new document that you claim takes precedent over your final parenting plan?
December 22nd, 2021.
And it says order to vacate.
Ma'am, do you know what he's referring to? I don't have that in my file.
Your Honor, he's going off child support, what he told child support.
No,
he's going off child support.
No, we had a hearing, Your Honor. She missed 2 of the hearings, and I was granted.
Are you saying that there's a new parenting plan in place with this court?
Yes, there was an order to vacate the old one because she didn't show up to court, and she knew all this. That's why we've done 50-50 for a year and a half. There's never been a safety concern. CPS was called to our house. They came in, they seen everything. They shook our hand. They apologized for having to be here. This is purely out of spite, Your Honor. I just want you to see that, please. I'm at fault in a lot of areas, okay? But I am not a bad father. This is a good household, okay? It goes so deeper than what's on the surface right now of things that have gone on.
Sir, are you saying, hold on, sir, on December of 2021, are you saying that you're able to file with me a court document that changes visitation?
Yes, yeah, I got it. It states 50-50. I can send that to you. I will go to the library today, get it printed out.
Ma'am, is it your statement to me right now that is not accurate?
Yeah, that's just what he told child support, and I didn't fight him with child support because I don't want his money.
Okay.
And it's not child support.
Okay. So here's what I'm going to do. I'm going to set this over 1 week. Mr. Bondurant, if we get to next week's hearing and what you have filed with me is not a parenting plan that changes custody, I frankly can all but guarantee you will be in contempt of this court based on what I'm reviewing in our file that does not allow you to have the child for this sustained period of time. But hold on, sir. I'm going to give you additional time because originally you should have had 30 days to respond to this. So I'm going to give you an additional week. You're going to be back on August 16th at 9 a.m. You have to have filed that new order or whatever document you're relying upon for your authority to have the kiddo for this sustained period of time. If I don't have that next week, or if what you filed doesn't actually say that, then we are going to be moving forward on the contempt motion. Okay?
Okay.
Ms. Flick, anything else right now that you need from the court? I know you were hoping to move forward today. I think there's enough question in my mind about what order we're really working off of. I want to make sure I have all the evidence in front of me. And then next week we will move forward on your motion.
Okay, I just have an appointment with my lawyer August 16th at 11.
Okay.
And like,
So
even if it was,
go ahead and log in, unless you want to push it to the following week to see if your lawyer would.
no, I want my daughter back. Like,
And
right away,
understand,
so-
Your Honor, I've gone just as long as and siblings have here without seeing.
Mr.
Lala.
Bondurant, you're having a real issue with talking over the court. Just wait, okay? Okay. So, ma'am, if your appointment is at 11, log on to this hearing at 9 a.m. and send a chat message stating that you have a lawyer appointment. You need your case called by 10 o'clock.
Okay.
Okay. And we'll make sure to get that done. And then Mr. Bondurant, go ahead and file what you believe supports your position, and we'll move forward August 16th at 9 a.m. Okay.
Your Honor, Casey Looney with State on behalf of Child Support. I just want to give the court a reminder that this is a case where we don't currently have jurisdiction. There's no legal parentage established. We were supposed to do a UCC JEA conference. I have not received any information regarding having that conference set, so we can't go forward with the parenting plan today.
Yes, thank you, Ms. Looney. And our judicial, so for the parties, Ms. Despain, Mr. Wyand, our judicial assistants have been working actively. I believe, I'd have to pull up my email, but I think it's Columbia County. Does that sound correct to you? Yeah. They've been working with Columbia County to try and get that UCC JEA conference, which is the Uniform Child Custody Jurisdiction Enforcement Act. I think I got that right. And we have just not had, I don't want to say cooperation. We just haven't had them respond to set a date, I guess is the most diplomatic way I could say this. So we do need to just go ahead and set you all out until we can get that done. It is on their radar, and I can assure you they are actively working on it. So given how long it's taking, my thought is to set this out to September 6th. Will that work for the parties?
That is fine. And Lincoln will officially have lived in Washington, and you guys will have jurisdiction at the end of October, even if it doesn't come through before then.
Okay.
Your Honor, I just, if I can, I just want to clarify that we would not be able to do the parenting plan until parentage was established, just so that Ms. Despain understands that that piece would have to happen first.
Absolutely.
That would not work for me, for the father. Kendra has refused to discuss anything referring to my son. She will not let me talk to or see him. I have not seen my son or talked to him since April 20th. Like,
yeah. So, sir, what we're saying today is I don't have jurisdiction at this time. I have not, I'm not satisfied that this court has jurisdiction. So I'm not going to address those concerns today. We do have to do the UCC JEA conference first.
Oregon won't talk to me at all. They won't talk. Oregon will not talk to me. They said it's in Washington, and they said it's over with.
I understand your frustration. Believe me. I'm going to set this to September 6th at 9 a.m. We'll just continue this matter to that date. If we get that UCC JEA conference first, we can renote this on a sooner date because the two of you actually participate in that conference, or we give you the opportunity to participate in that conference. So you will know when it gets done and when it's scheduled for. Okay. Ms. Looney, anything else on this case?
No, Your Honor.
Hey,
thank you.
Who can I contact to get a hold of somebody to see my son? Because I haven't seen him in, since April 20th, and
sir,
his mother won't let me see him at all.
Yeah, I can't give you legal advice, sir. If you want to try and reach out to legal aid or a family law attorney, please feel free to do so. Okay, until I establish jurisdiction, I can't make any rulings. All right.
Okay.
Thank you both.
Thank you.
And I think I did see proposed orders from Ms. Linden.
That's correct, Your Honor. But may I put into the courts that Miss Linden didn't serve me until July 8th. No, August 18th. I had only 6 days or 5 days to prepare for this response.
Okay, so let me just get there. I totally hear ya. I'm just pulling up your docket. Just give my computer a minute to get caught up with us.
No worries, Your Honor. I just wanted to put that into the courts.
Totally understood. So I am seeing, just going to see if I can tell exact service dates here. Lyndon, do you know when Mr. Adams was served?
According to the paper, I have July 18th.
July 18th?
That was July 26th.
Say that again, sir.
There was a court date for July 26th. I was served July 18th, as Miss Linden had confirmed. But I also had fallen into technical difficulties. I was in docket B when the court case was in docket A.
So this is when we were here last on September 26th. I was concerned about service, and I did ask for proof of service to be filed with the court. And I just still don't have that unless I'm missing it. I don't have the proof of service. But Mr. Adams, let me ask you, are you stating that you were served the summons for this case on July 18?
I am stating I was served, but testing to this, I'm not accepting it due to the fact that I have a parenting plan that I had filed with Miss Linden in Pacific County, and she's refused to go through their orders.
Okay, so just I know, sir, just calm down. I know this is stressful. Let me ask you a question, because I see in your response, you mentioned Pacific County. What type of action is open in Pacific County?
So the actions that me and Miss Linden were supposed to do was we were ordered to do a parenting class, and then she was ordered to do a mental evaluation, health evaluation, and she was also ordered to respond through Pacific County. Keep it there, because that's where a lot of the background was.
So is that where, so let me ask, have you guys already started a family law action in Pacific County?
Yes, Your Honor.
Has Pacific County entered a parenting plan?
We are trying to come to the agreement of coming up with one, but Miss Linden is non-compliant with Pacific County.
Okay, Ms. Linden, let me just turn to you. Is there an active case going on in Pacific County?
No, because when we had court that day, it was thrown out because he did not have all his paperwork, and I have not been served since by him.
But I mean, so are you agreeing that there is a parenting plan action in Pacific County that's open?
No, ma'am.
Yeah. So let me just ask you why you have filed here, Ms. Linden.
I have absolutely no way to Raymond or anything like that. And I was told by the clerk's office here in Cowlitz County that it would be best to do all of the paperwork here because I have no way there.
Did you say that you can see that Pacific County?
It's 2-2.
Okay, give me just a minute, folks, here.
No worries, Your Honor. And if I may put into the courts that Miss Linden makes it hard to serve her because her family denies that she lives there and her job refuses to be served there. So in order for me to do any type of proceedings, Miss Linden makes it hard. I have no communication with my son. I haven't seen him within a year, and I've been asking Miss Linden for just visitations. But again, Pacific County has been dealing with this, but Miss Linden just backed out for no reason. And I also stay in contact with Pacific County too to let them know about these court dates.
You guys had a parenting plan hearing on June 15th.
Yes, Your Honor, that is correct.
Hearing was stricken.
Because she failed to be served because her family said she didn't live there. And then we went to court the next time and the judge ordered her to give the address. So
yeah, Ms. Linden, you guys already have a proposed parenting plan action filed in Pacific County that is actively on their docket. So I'm confused why you have filed here. Or you're essentially asking this court to redo what Pacific County is doing?
And if I may add, Your Honor.
Well, no, sir, just hold on. I'm asking her. She's the petitioner.
Not a problem.
Go ahead, Ms. Linden.
At the Pacific County hearing, I was told by the judge that I could file here because he did not have all of his paperwork done. So I took that action to file here.
How do you all typically deal with that?
I would say that I use CCJA.
So what we're gonna do, I'm not gonna take any action today. I'm not sure this court has jurisdiction to even hear your new petition and summons, ma'am. Are much like I talked about with the prior case where there's two different courts involved, we will set up a conference with that judge. So I'm gonna give you a return to court date here of September 6th.
Honor.
Hold on. No, just hold on, just a second.
Yeah.
September 6th, 2023. And then my judicial assistants will reach out to Pacific County for a conference on which court is handling this matter. Ms. Linden, I'll just tell you, it's highly unusual for someone with a pending parenting plan in a different county to then refile in a new county. I do think it's problematic, but we'll reach out to that court and let you all know which court is going to take jurisdiction of this. Go ahead, sir. You wanted to say something?
Yes. I filed through Pacific County multiple times for a court-appointed mediator. Is there a way that I could possibly get a motion?
Yes, I think what you need to do, and I can't give legal advice, but you, sir, if that's what you're asking for, you can ask Pacific County to appoint a guardian ad litem to your case.
Okay, now my question is, how do I pertain to get it back into Pacific County? Because at this point, Miss Linden is bringing it here. I've traveled all the way here today due to the technical.
Yeah, and I'll just tell you that your case is active and open in Pacific County. There's nothing you need to do there except file a motion.
And see, that was the thing. When we went to court with Pacific County, I was supposed to file a temporary order, but Miss Linden not do you guys instead.
And if so I have to be kind of careful not to give legal advice. This is a complicated situation where you may want to reach out to legal aid. But what I've done on this case is set a review date for September 6th. In the meantime, my court will be reaching out to Pacific County, and hopefully we can make some sense for you all of where this needs to go and which county you need to be in, okay?
Oh, come back here on September 6th?
Yep, just via Zoom. You can do that from any Zoom. You can do that from your home. You don't have to come here to do it.
Straight in, and I have no problems. I can, that's the biggest problem is I have it on my phone, but getting the meeting ID number, I got the wrong one. And I have no problem coming here. It's only an hour.
Okay. Ms. Linden, any questions for the court?
No, ma'am.
Okay.
Oh, and Your Honor, if I may ask one more thing.
Go ahead.
After we do the conference meeting with Pacific County, is there a way I could start establishing visitation? Because Ms. Linden has agreed multiple times and denies.
Yeah. So, sir, I understand your question. What I can say, I haven't established that this court has jurisdiction right now, so I can't address visitation. Hopefully we'll have some more clarity by September 6th for you. What I can say is that if Pacific County has temporary orders in place, you all should be following them.
I don't have a temporary order because Ms. Linden can't do that. So that's where we're at the moment.
Okay, understood. Well, we'll try and get some clarity, but feel free you can file a motion in Pacific County that it is an active and open case. So, okay.
Thank you, Your Honor.
Great. Thank you both. You're free to log out. Thanks for your patience.